2024 CR 8783, state versus Austin Damian Diaz.
In custody, no call?
No, he's here.
Oh,
Is-
he's not?
Wait, is Austin Damian Diaz here? No, he's in custody. 2024 CR 8654, state versus Alejandro Esparza. Thank you, sir. 2024 CR 8791, state versus Dakari Jaheem Williams.
Attorney running late, unspecified.
2024 CR 10986, state versus Damian Acuna. Thank you. 2024 CR 11281, state versus Antonio Avalos. Antonio Avalos, is he in custody?
No, I don't know that, but no call.
Okay. We'll wait on that. 2024 CR 12097, state versus Brad Chandler Simpson.
Custody.
Thank you. Thank you. 2024 CR 12153, state versus Aaron David Pompey. Aaron David Pompey, bond forfeiture.
No call.
2024 CR 12438, state versus Jason P. Sanchez. Jason P. Sanchez.
Attorney running late, other court.
Okay, bond forfeiture. 2024 CR 12727, state versus Nicole Ramirez Canales. Nicole Ramirez Canales, custody.
Attorney running late, 15 minutes.
2024 CR 12990, state versus John Mark Bray Jr.
Custody.
No call.
2025 CR 0546, state versus William Alexander Baquedano Hernandez.
Custody.
No call.
2025 CR 0561, state versus Saban Ochoa Sanders. Thank you, sir.
Late, other court.
2025 CR 0717, state versus Brian Allen Cummings. Brian Allen Cummings, is he in custody?
I think he's in custody.
Okay, that's fine, thank you.
Attorney, no call.
2025 CR 0838, state versus Shane Lawrence Hummel.
Mr. President, will confer objection.
Okay, is that you, sir? If you could stand up and call your name, please, okay? Thank you. Thank you, counsel. 2025 CR 1004, Esmeralda, state versus Esmeralda Rangel Ortega. Esmeralda Rangel Ortega,
Attorney running late, other court.
bond forfeiture. 2025 CR 1047, state versus Joshua Pedrosa. Thank you, sir.
No call.
2025 CR 2067, state versus Matthew Hyams McBride. Thank you, sir. Thank you, counsel. Thank you, sir. 2025 CR 2164, state versus Carlos Castro. Thank you, sir.
No call.
2025 CR 2397, state versus David Silva.
Custody.
Attorney running late.
2025 CR 2424, state versus Jose Jesus Lopez Jr. Thank you, sir.
No call.
2025 CR 2633-02, state versus Eugene Fitch.
Custody.
Attorney running 30 minutes late.
2025 CR 3267, state versus Sebastian Homero Escobedo.
Will
Thank you,
confer
sir.
objection.
Thank you, counsel. 2025 CR 3729, state versus Keon O'Shea Hector. Keon O'Shea Hector.
Attorney running
Bond
1 hour
forfeiture.
late.
Okay. 2025 CR 4638, state versus Ruben Joel Reyna.
Custody.
Attorney running late, unspecified time.
2023 CR 1115, state versus Richard Aragon. Thank you, sir.
Attorney running late, 30 minutes.
2023 CR 8828, state versus Henry Earl Johnson III. Thank you, sir.
No call.
And 2024 CR 6560, State versus David Lee Graham. David Lee Graham. Okay, bond forfeiture.
No problem.
Okay, that's adopted, you all may confirm. And let's see if we can get Mr. Simpson on here. Tim? Simpson? Okay.
All right, we're about to do the hearing, so I'm about to have the parties that are gonna be on the hearing, get set up, we stand on this side, defense counsel on this side, please. If you did not hear your name called, you have not checked in, you'll leave the line here at the gate, so I get you checked in.
Did you confer already?
And if you are not media, you need to not have your phone out, there's no recording, there's no photography, if you are not media, if you're media, use your phone to step out in the hall.
He already announced it. He already announced it. Everybody's on the thing. Let's just do it like this. We're gonna do it like this.
This is so hard. When I try to hear it,
I'll tell everyone to speak.
they're gonna have to.
Okay. Did you end up finding something on the woman?
Yeah, we had the wrong, there was a typo, had a 0 instead of a 9 on Saul's case number.
Okay.
So what I'll do is I'll do a pen and ink correction on it.
Yeah.
We'll go forward. I want to make sure you keep the one that she signed, because I want that on the record that she's willing to do it.
Say that she's willing to take the check. What? Sign the letter?
Oh, the motion for neutral.
Oh, yeah. Okay.
I don't regard the parties intending to make any additional arguments.
Okay.
I'll probably
We can do it from up here then. We can do it from up here.
I just, rearrange it.
Yeah. No. We're gonna do it from up here.
Okay. That's the first one we're doing?
Yeah.
Okay.
Good morning, how are you? Everybody ready for fiesta?
Yeah.
I mean,
Yes.
it wasn't 3 days notice, I wasn't planning on, but no.
Good morning. Yes, sir.
I think we'll handle that later. Okay?
That's what I was thinking.
You want to make, bring the, okay? What date do you want to come back? I would prefer one of these days, because we're gonna start following here. If you can get here by 9, we'll send you here, but you need to be here by 9.
I'm ready, Judge.
We need to defend it.
Okay, do you need a reset or you're okay? Okay, there I have it.
As soon as they bring them out, we'll start it.
Yes. It worked. So, he didn't actually document, okay? You just got hired or did you get hired? Okay, so I can put it on trial document, did you get discovery and all that? Have you received everything? Okay, are you ready to do it? Okay.
You get ready right
So
now?
I'll give you one more reset and then I'll put it on the trial document.
We're waiting. Simpson. I told him to bring them out right off the bat. I told him to bring them out right off the bat.
Today's 2-bagger. And I normally have them right, you're right.
Mm-hmm.
Okay, let me give you your copies. Thank you. Have a great day.
Do any of you suffer from sinus?
Sinus?
Yeah, the sinus.
No, not as bad here or down, when I lived in Corpus I did, but
Really?
not so much here.
I never had allergy sinus until I went to Austin. When I went to exhaustion, all of a sudden it was sinus issues, allergies. I don't have to know what.
They're so bad this year. They're so bad for me and my dog. I never had children here.
I have a lab that's always sneezing.
Oh, yeah, it's probably allergies.
I'm not gonna do them, knock them out.
Poor baby.
Yeah.
I'm gonna check right now. Yesterday we were on an injury, so I'm gonna have issues on this one today.
Yeah, it's been doing.
Oh, that's how it was yesterday. Yes. Thank you. Have a great day.
Do you want anything additional from us today?
You wanna do a brief argument, but very brief.
Okay, you'll come back. Okay. Yeah, did you tell him that?
Are you gonna need a minute just to talk to him? Or no?
No.
Cause it's
Ronnie Joe Neal's son's doing good on probation.
Who?
Ronnie Joe Neal.
Oh my God, that's a name I haven't heard of last minute pass. His son is on probation.
Yeah, remember, I came and talked to you last week. I got the kid.
Oh, wow.
He picked up an ag rob that he was kind of only peripherally involved in. He got deferred.
Wait, this is not the child from,
No, it's that child, Pearl Ann's. Yep. He doesn't know.
oh, wow.
No, he does not know. We did. When I came and talked to you, I was trying to figure out how we could go about letting, this is 144th, the judge know without having to say it from him,
Uh-huh.
because he was 18, well, he was 17, and I don't think he has a right to the records until he's 18.
Yeah.
But we wanted the judge to know, so I just came and asked you how you thought we should do it. But, we'll let the judge know. He seems to be doing well.
Well, I wish him the best. Those difficult circumstances.
And it seems like Pearl's doing pretty good too. She lives in Austin, I guess.
Mm-hmm. All things considered.
Yeah.
What year did he die at?
I'm sure, that was probably right at the turn of the century, wasn't it?
Yeah, around 2000. Right?
Yeah.
Yeah. So from the, what, City Hall?
I think it happened in 99 or something.
Yes. You know what we're talking about?
No, I don't.
I just think that. I just remember that. Yeah. That's kind of.
One year, I don't know.
It was around 2000. It was around 2000. I think.
Here in 2013.
Mm-hmm.
Alamo Heights Teacher Foundation.
Well, you know, that's the pretext under which they got into that one.
Say it again?
That's the pretext under which they got into the women's.
Oh, yeah, right.
They started doing the laws. Hurry up and wait. I need the motion to quash, the defendant's motion to quash is not in here.
Everything was together
Yeah, but
in the packet.
I mean, I just wanna be able to write on the order. No, the actual motion to quash, his motion to quash, the defendant's motion to quash the indictment. Let's see what it's, let me see. Yeah, this one.
Stressed about sentencing. Monday's the case. Supposed to be. CTD? It's gonna be double. No. See, it's still that hanging up, but I moved to pick, but I don't know when it got started. Early or if it is to come. It's, Jessica Duffy and Alexis. Jessica.
Well, now it's going in a circle.
While we're waiting,
Yes.
should we figure out the next dates? I know the date
Yeah.
last time about also scheduling order or.
Well, is the discovery complete?
No, discovery's not complete, but I don't know if we want to set some kind of compliance deadline or.
Well, what I'll do is, I'll give you all the scheduling order, I don't wanna do a scheduling order, because then I know it's gonna happen, we're gonna end up moving it, let's just agree to a certain discovery deadline, okay, for now. Okay, your time, sir, are you ready, Colin?
Yes, sir.
Okay, 2024 CR 012097, state this is Brad Chandler, Simpson. Will the lawyers please state their names for the record?
Casey Sandoval and Willem Van Zeven for the state.
Stephen Gilmore and Brittany Jones, Mr. Simpson.
Okay, counsel, will you step on this side?
Sure.
And sir, are you Brad Chandler Simpson?
Yes.
Okay, now we're back here again because, we had a hearing on the motion to quash the indictment last week, the defendant's motion to quash the indictment. But, the state wanted an opportunity to file a response, and you did yesterday, I believe.
Please speak up, Judge.
You-
Friday, Judge.
Okay, you filed it on Friday and then the defense, replied to that, correct?
Yes, we filed a short response.
Okay, now, let me also get, you now filed, another motion for production of grand jury evidence pursuant to Article 20.02. That was filed on the 28th, so on that, we're gonna hold off until a later time to see, give the state some chance to, an opportunity to answer.
Of
okay?
course.
And now, with regards to, the motion to quash, and we, I think, are on count 1, paragraph B, the act clearly dangerous to human life, do you have any argument?
Judge, just a brief further argument. I want to refer you to a section in Lugo, which is a case that the defense cites, and just point out that Lugo says that A1 and A2 are functionally equivalent, and what they bring up is that a knowing murder under A1 implies a knowing murder under A1 implies an act that is objectively clearly dangerous to human life. So they are functionally equivalent, A1 and A2. So, and defense has conceded that A1 requires no additional notice. So I just want to point out that equivalence between A1 and A2. And then I want to just touch briefly on the Marquez case that I gave you yesterday, which has the exact same indictment language as our case, A1 and A2. And I think the court's analysis in that case implicitly rejects the defendant's argument here. What they do is they go through an analysis of the evidence linking the defendant to his wife's death, and it's remarkably similar evidence to what I expect in this case. And what they say at the end is the jury can infer that act from evidence linking the defendant to his wife's death. So in that situation, what the court's saying is that there can be no evidence of the act itself, and the jury can still infer that and find that A2 murder. So for those reasons, and also for the reasons in the brief, the first and second brief that the state has filed with the court, we're asking the court to deny the motion.
Okay, and counsel?
Judge, just I guess to briefly respond, nowhere in the entire opinion in Marquez do they discuss notice. They're only discussing sufficiency of the evidence, what the jury heard at trial. State versus Rosenbaum, the Court of Criminal Appeals says we don't test the sufficiency of an indictment based on the evidence they expect to see at trial. It's tested by the law. And the state invited defense in its latest filing to envision hypothetical situations where an act may not be clearly dangerous to human life, yet still result in death. And the state, of course, is aware of hundreds of vehicle-related cases that they file every single year, where there's an act that may or may not be per se clearly dangerous to human life. Unless they're alleging a firearm or some per se deadly weapon, there are hundreds of acts that could be dangerous to human life or could not be but still result in death. Lastly, Judge, if the state wants the benefit of presenting this case to a jury on a lower mental state, not intent or knowingly committing a murder, but rather a lesser intent to cause serious bodily injury, it follows that they also assume a greater burden to plead in their indictment, greater specificity, to put me on notice so that I can defend against whether the act occurred or whether the act, if one did occur, had any link in the chain of causation that resulted in someone's death. And I can't do that unless they tell me what it is.
Anything further?
Nothing further from the state, Judge.
Nothing from defense.
Okay, so with regards to count 1, paragraph B, your motion to quash is denied. Okay. Of course, if the state comes into more information at a later time, then you act appropriately on that, okay? Anything else from your side?
Nothing from the state, Judge.
Nothing from defense, Judge.
Okay, that closes the record on this case. Thank you very much.
Give him a 30-day status hearing.
Yeah.
Okay.
Yeah, yeah, I'll go check. Thank you.
I still.
Gloria.